Can your employer deny you a break even if it helps you manage a mental health condition? Well, that's exactly what happened to a teacher in New York. She had PTSD, a long-standing accommodation in place, and then one day it was gone. This case is about whether the law protects workers with invisible disabilities and if a policy change at work can be used as an excuse to take away your right to an accommodation. By the end of this video, you'll understand how mental health conditions like PTSD are protected under the ADA, why your employer can't simply change the rules to take away your accommodation, and how denying even the smallest support, like a short break, can violate your rights. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider, where we talk about real legal cases, real lessons for real people. When we think about disabilities, we often picture physical conditions like a broken arm, vision loss, or hearing impairments. But not all disabilities are visible. Some, like anxiety, PTSD, or chronic depression, can't be seen with the naked eye, but they are just as real and significantly impact a person's daily life. It's important that these invisible disabilities are taken just as seriously as the ones you can see. In today's case, we are going to look at an example of that, how an employee's mental health condition was handled at work and the steps her employer took or didn't take to respond with the sensitivity and support she deserved. Okay, let's talk about it. The content shared on this channel is for informational purposes only and shouldn't be taken as legal advice. Always consult a qualified attorney or HR professional for guidance on your specific situation. And hey, don't forget to like and subscribe. This case starts with a woman named Angel Tutor. She was a math teacher who spent about 20 years working for the Whitehall Central School District in New York. She started as a substitute teacher and eventually became a high school teacher. But behind the scenes, Angel was dealing with something incredibly heavy. She had PTSD, the result of sexual harassment and assault by a supervisor at a previous job. And it wasn't just emotional, her symptoms impacted everything. She struggled with basic tasks, developed a stutter that made it hard to communicate, and had nightmares so intense that they sometimes made her physically sick. She had been hospitalized 3 times for psychiatric care, and she took multiple medications just to manage daily life. And despite all of this, she kept showing up. She kept teaching. She held on to her passion for math until one accommodation that made all the difference got taken away. And in 2008, that's when things became really tough for Angel Tutor. Her PTSD symptoms started getting harder to manage, even with therapy and medication. So, in partnership with her therapist, she asked the school for a simple accommodation, ability to step away, step off campus for 15 minutes during her morning and afternoon prep periods. Those were the times when she didn't have students. And she used those short breaks to get some space to breathe and just to reset, because being in the school environment itself often triggered her symptoms. In 2016, things took another turn. A new school administration came in, and suddenly there was a new policy. Teachers weren't allowed to leave campus during their prep periods at all. And so Tudor tried to stick with the routine that she had used that had helped her manage her symptoms for years. But when she stepped off campus, she was written up for insubordination. She explained that she had a long standing accommodation in place, but the school told her the paperwork they had wasn't good enough to prove she needed it. Instead of jumping through more hoops, Tudor took paid sick leave. Then she requested FEMLA leave for the fall semester, and her doctor confirmed the seriousness of her condition, PTSD with severe anxiety and agitation. And during that time off, she wasn't able to teach. She had to attend an intensive outpatient program 5 days a week just to stabilize her symptoms and regain control. When Tudor came back from FEMLA leave in January 2017, the school district offered her a partial fix. She was allowed to take her morning break and she could take an afternoon break too, but only on days when a librarian was available to cover her class. If no one was available, then Tudor did not receive a break. That was the deal. And that setup stayed in place for the next 2 school years from 2017 through 2019. But still, Tudor kept doing what she had to do in order to manage her symptoms. During the 2019-2020 school year, she left campus during study hall period on 91 out of 100 school days before everything shut down for the pandemic. No one at the school ever gave her clear permission to do it, but no one directly stopped her either. She was never told, yes, you're allowed to, so every time she took that break, she felt like she was breaking the rules. And instead of helping her feel better, those breaks made her more anxious because she thought she was risking her job just to manage her symptoms. So eventually, Tudor filed a lawsuit against Whitehall School District in New York. She alleged that the district violated her disability rights by refusing to give her that 15-minute afternoon break during the 2019-2020 school year because it was an accommodation that she had previously been granted to manage her PTSD symptoms. But here's where things get really interesting and legally important. The school district argued that Angel didn't really need the accommodation because she was still doing her job. She was still showing up. She was still teaching. She was still performing and meeting expectations of her job as a teacher. In other words, they said, if you can do your job without the accommodation that you're requesting, you really don't have a claim. And the lower court bought it. They threw the case out, ruling in favor of the school district. But the lower court's decision didn't deter Angel. She wasn't done. She appealed, and the appeals court flat out disagreed with the lower court's decision. And this is where this case becomes a big deal. The appeals court said, no, that's not how the ADA works. Just because someone has the ability to technically do their job without an accommodation, that doesn't mean the employer is off the hook. The ADA says employers must provide reasonable accommodations to help employees perform their job unless it causes an undue hardship. So Angel was entitled to that break because it helped her manage her condition and perform her duties effectively without unnecessary stress or fear. Let's pause for a moment just to clear up some common misunderstandings about the Americans with Disability Act because there are a lot of myths out there about who qualifies for an accommodation and when employers have to honor them. So let's break it down. We're going to talk about it in terms of myths versus facts. Myth number one, if you can still do your job, you don't need an accommodation. Actually, the ADA says you may still be entitled to a reasonable accommodation, even if you're able to perform your essential job duties, because it's not just about getting the job done, it's also about your ability to do it without putting your health or mental well being at risk. Myth number two, employers can deny an accommodation if the policy is the same for everyone. The fact is, equal policies, they don't override disability laws. If a policy ends up hurting someone with a disability, the employer has to consider making exceptions because fairness doesn't always mean treating everyone exactly the same. Myth number three, mental health conditions like PTSD aren't covered by the ADA. The truth is, conditions like PTSD, anxiety, and depression are protected under the ADA, especially when they interfere with daily activities like communicating, concentrating, and managing stress. Myth number four, your employer can just keep asking for more paperwork anytime they want. Employers can ask for documentation, but it needs to be reasonable. They can't create endless hurdles or make it harder than it needs to be. Once your condition is documented, the process needs to move toward a solution, not become a power struggle. Myth number five, taking a short break isn't a real accommodation. Actually, it is. Accommodations don't have to be expensive or complicated. Something as small as a 15-minute break can make a big difference for someone who's managing a disability. And in many cases, that break is protected by law. If you've heard of any of these myths before, you are not the only one, but the law is clear. Employees with disabilities, including mental health conditions, do have rights, and accommodations matter. Angel Tutor's case reinforced something a lot of people tend to forget. Accommodations aren't just about ability, they're about dignity. They're about supporting people in ways that reduce harm and allow them to do their best work because mental health matters. PTSD, it's real. And a 15-minute walk to regulate your breathing and manage your anxiety, that's not asking too much. This case is a reminder that we don't have to be on the verge of collapse to ask for help, and that employers don't get to wait until we break before stepping in. If you've ever been denied an accommodation, or if you weren't sure whether what you were asking for even counted, this case shows that the law may be more protective than you think. Employers have responsibilities, and mental health is just as valid as physical health when it comes to ADA protections. If you want to learn more about how the ADA protects workers, check out the full ADA playlist on this channel. I'll link it in the description. And if you found this video helpful, please like, subscribe, and share it with someone who needs it. I'm Harlow Reed, and I'll see you next time on the HR Insider, where we help you understand your rights one case at a time.